Welcome to Dateline, everyone. I'm Lester Holt.
But once the two women were in the hallway, out of the view of the cameras and the jurors, Andrea reportedly threatened her. The best friend's lawyer says he overheard the confrontation.
Andrea tells her, I understand why you did what you did, but now you're going to have to live with what I'm going to do.
Of hearing angels and demons, here's Elizabeth Vargas.
Good evening. Citron's lawyer Jay Abt witnessed what happened next.
She tells her, look, I understand you had to do what you had to do, but now you're going to have to live with what I'm going to do. She says it in an ominous way, and then she gives Shayna another kiss, but this kiss, it was like the kiss of death.
What about that, Jay Abt? To think, to have the wherewithal to think after you've murdered 4 people, including a little boy, to erase the home video. How are you going to get around that in court?
I'll tell you how I get around it. I absolutely believe that this man Wint is not guilty, and I'll tell you why. I think as an employee of the homeowner, he was also a victim of the crime. In other words, the other people who were perpetrating this crime held him hostage along with the homeowners, and he just narrowly, luckily escaped the crime. That's why his DNA is at the scene. That would explain it away. And he too could be a victim of being kidnapped and held hostage, and he narrowly escaped with his life and somehow escaped the people who perpetrated this crime. Well, you know, it's a great tagline to say that doing a participation trophy is the wussification of America. But in reality, having kids get trophies or acknowledgement for participating provides important things for their self-esteem. There's a lot of psychological studies that have shown it improves self-esteem. It improves team building, and it enhances this idea of team building among children. And it also increases participation, and that's really the most important thing. We have a huge obesity problem in this country, and in order to keep kids involved in sports and other activities, by giving them a participation trophy, it encourages them to keep going.
Joining us now with reaction from Miami, retired Judge Alex Ferrer, who also served as a police officer in Florida, and from Atlanta, Jay Abt, a criminal defense attorney. Jay, let me begin with you. Is there any chance of a fair trial here?
No way. The first problem is that you have this 35-year-old prosecutor, which is very young. She's only been practicing law at most 10 years. She's probably at most tried 6 murder cases on her own, which means she's very inexperienced, and she's rushing to indict this case for political purposes. I mean, it's clear that it's a political move on her part. Everyone in Baltimore must love her now for having rushed to do this, but she didn't use a special prosecutor, which clearly should have been done to eliminate the appearance of impropriety, and her husband sits on the city council. Now you find out the attorney for the Gray family is one of her biggest financial donors for her political campaigns.
District attorneys in California are saying that Uber is ineffective when doing criminal background checks.
Right, so no private industry really has foolproof background checks. The national database that the FBI keeps, called the NCIC, or National Crime Information Computer, is the comprehensive, authoritative record on criminal records. And private background checks aren't always as thorough as they should be when doing this. Having said that, I think Uber is going to hit a major problem with litigation at some point, if not right now, because if they're letting murderers and child molesters and rapists as drivers, eventually they're going to get privately sued because somebody's going to get killed by one of these drivers, and they're going to have legal liability. I would tell him, you're not going to be speaking publicly for the next year, because we're going to wait till the heat dies down towards a child, but not with malice. That allows the state to prosecute that person and put them in front of a jury on those negligent acts towards a child.
Abt says prosecutors must prove there was child cruelty in order for them to get a conviction for the second-degree murder.
I think it's the reason the legislature passed a law like this is to ease the burden on prosecutors in showing what the standard of proof could be when there is a death to a child. I actually agree. I think they do, because it seems like there was an agreement. There was actually a contract between Wells Fargo and the Vikings whereby Wells Fargo wouldn't put illuminated signs or mounted signs on their buildings in order to get the zoning from the city to be near the stadium. And they've gone ahead and started to build that. So it seems like a pretty straightforward lawsuit where the Vikings will win. My question would be really, first, if I were Wells Fargo, why not come up with an ounce of creativity and just paint the words Wells Fargo on the roof and use that as leverage to get a better deal rather than using mounted or illuminated signs? The second question I have is, if I'm the Vikings, instead of just filing a breach of contract lawsuit, file an injunction. Prevent them from actually taking these steps to mounting this stuff. And they haven't done that. I've read the lawsuit. I've actually reached out to them for comment. They don't have a reason why they didn't seek an injunction. I think they should have.
Maybe they're listening to this advice.
These imitation cell phone towers the government uses to track people in real time. And what we found out through that trial was fascinating in terms of the government's ability to not just collect data about the accused that I was representing, but other people who were even near that cell phone tower. They're using it to get the historical data based on where anyone is located at any given time. They can get text messages, they can get phone calls, and they're doing a lot of this without a warrant. They're doing it because the government is so in bed and so closely tied to these cell phone carriers. Sometimes they're just sending them a letter or sending them a subpoena, and it's fascinating how much they've expanded their ability and their power to govern and look at regular citizens like you and I and what cell phone data usage we're using in terms of where we're located, who we talk to, what our text messages are, and it's very disturbing. This year, the U.S. Supreme Court decided Riley versus California. It was a groundbreaking U.S. Supreme Court case that said the government can no longer, if they have your physical cell phone, look inside the cell phone without a warrant. However, the court really needs to expand that decision. Mr. Roth is right. The reasonable expectation of privacy has diminished, but we should fight back against it. We need to expand what our privacy rights are, and the Supreme Court should expand Riley versus California to include not only cell phone tower data, but this Stingray technology so that the government isn't tracking people in real time without their knowledge and without their consent.
It's incredible now to try to apply a document written in the 1700s to modern day technology. The challenges are vast, and that's why we have folks like you guys to break it down for us. Richard Roth, E.J. Abt, sure appreciate you guys being here. Your insight. Fascinating debate. Thanks, fellas.